Elizabeth Denham, UK Information Commissioner and Chair of the GPA, has the floor. She will be moderating this session.
Hello, and welcome to this session. Looking at privacy and COVID-19 vaccine passports. In my opening earlier today, I proposed that we keep two questions in mind throughout all of the panels and throughout the conference. Do we understand how people feel? And how does privacy stay relevant? And I think there can be no topic where this is more relevant than around COVID vaccine passports. The need to understand how people feel about schemes that rely on the collection of sensitive health information of entire populations seems clear. But what is less straightforward is how privacy stays relevant when the stakes are so high. And this is the challenge that so many of us have faced over the pandemic. How do we make sure that privacy is considered in schemes that are so integral to opening up society, to lifting restrictions on our civil liberties and travel, and to revitalizing our economies? Alessandra Pierucci is very well placed to discuss these challenges. As chair of the Committee of Convention 108, Alessandra has a unique insight, informed by her involvement with a treaty that lists more than 50 signatories through Europe and beyond. Alessandra also has a vast experience in data protection as a lawyer and as a regulator. Alessandra, the floor is yours.
So good morning and good afternoon and good evening to everybody. Let me firstly express how grateful I am to have the chance to participate in this outstanding event. My sincere gratitude goes to the INAI for the splendid organization of this conference, the whole GPA Secretariat for the incredible work done, and to Elizabeth Denham for her vision and her precious role in the development of the GPA. I'm honored also to take the floor in my role of chair of the Consultative Committee of Convention 108 of the Council of Europe, whose activity is for me an extremely and continuously enriching exercise. The Council of Europe, for its human rights vocation, has been having an active role, on which I would tend to focus today, in the consideration of the numerous angles, questions, ethical issues raised by the measures adopted by states to contrast the widespread of the pandemic, including in respect of the initiatives of many regulators to issue documents or certificates that prove the immunization and good health of people. One of the questions posed by the introduction of this speech published in today's agenda is there a proportional relationship between the measure adopted and the protection of personal data? We are almost approaching our second year of coexistence with the pandemic, and many questions like this still animate the debate. The one of the background being, are certificates a tool to regain our liberties and rights, or could they trigger unbearable forms of discrimination and widespread surveillance? Which liberties and rights are we talking about? To health, to travel, work, attend cultural or leisure events? We have been frequently listening to these questions, whose answers are not probably in the hands of the supervisory authorities solely. These questions are moreover intertwined with a considerable number of other issues, which as well have been raised in respect of vaccination passports, related, for example, to the vaccine distribution in the world and forms of vaccine nationalism, which create a new kind of global inequality between countries that are able to vaccinate their population and countries that aren't, thereby producing seclusion and discrimination of more vulnerable people. Therefore, provided that the ethical and the legal questions raised by certifications go beyond a pure data protection assessment, maybe I would try to answer the initial question, transforming it a little bit. How do we ensure the proportionality between the measures adopted and the protection of personal data? For sure, there are some elements that can facilitate the achievement of this proportionality, also as a lesson learned from the practice of these last almost 2 difficult years. As we all know, the setting up of such certificates must be provided for by law. Recommending that a legislative measure must accompany the introduction of this measure is essential, but not enough. A high quality of the legislative measure must be ensured, which means, first of all, that an accurate impact assessment must precede the introduction of such certificates to evaluate the repercussions of the measures being adopted, as well as to the effectiveness of already existing less intrusive measures. In data protection language, we would speak about a data protection impact assessment, but it's becoming clearer and clearer that such evaluation is intertwined with a more comprehensive human rights impact assessment. A human rights impact assessment which is consistent with Article 10 of Convention 108+, which not by chance speaks about the duty of parties to ensure that controllers and, where applicable, processors examine the likely impact of intended data processing on the rights and fundamental freedoms holistically considered of data subject. A high-quality legislative measure also means that the legal basis must provide an explicit and mandatory indication of the specific purposes pursued, a clear reference to the range of persons, authorities, and public and private bodies allowed to access the data contained in the attestation, the categories of data concerned, as well as the scope of the access authorizations. The failure to accurately identify the cases in which documents can be used, with the exclusion of the use of such documents in other cases not expressly provided for by law, is a relevant lacuna which renders the law unsuitable for constituting an appropriate legal ground. Of course, the definition of the purpose which would allow the use of COVID-19 attestations is a very sensitive operation. We knew from the very beginning that it was, and it is clear that the problem is still there. Using attestation of vaccination, negative test results, or past COVID-19 infections for known medical purposes, particularly for accessing services with no relation to prevention, health protection, and pandemic management, raises human rights issues which should be carefully considered, notably regarding the principle of non-discrimination. As also noted by the EDPS and the EDPB in the joint opinion issued on the 31st of March 2021 on the EU proposal on the digital green certificate to facilitate free movement during the pandemic, any further use of such certificate and its associated framework under a national legal basis should not legally or factually lead to discrimination based on having been or not vaccinated or recovered from COVID-19. Finally, in the evaluation of the high quality of the legislative measure, its rank can be also relevant, as the interference with fundamental rights cannot be done by fragmented provisions taken at the initiatives of different bodies out of a comprehensive strategy to combat the pandemic. What should be bear in mind is that the adoption of a legislative measure, far from being a mere formal fulfillment, is actually an opportunity to implement data protection requirements. The adoption of a legislative measure is an occasion to implement, for example, minimization. We don't need so many data for the correct functioning of the certificates. Personal data necessary to identify the data subject, unique identification of the certification, date of end of validity of the certificate are enough to ensure the proper purpose of the certificate. The certificate, moreover, should be based on a unique model, which, without revealing the different reasons why it has been obtained, whether for having undergone a vaccination, for being exempted from a vaccination, or for having recovered from the disease, or for being negatively tested. Passports revealing vaccination exemption may be used, for example, in some workplaces and reveal very sensitive data on the health of the worker to the employer. It is indeed very important to pay attention to the sensitive information that may be drawn by inference. And in this respect, the DPS and the DPB, in the opinion I have already mentioned, remind us, for example, that given the diversified status of the vaccination stages in the different member states and the order of priority, it may be easily inferred that a young person that has been vaccinated when others in the same age category have not, has a trait that justifies getting an early vaccination, such as being immunocompromised or having a chronic disease. The adoption of a legislative measure is an occasion to implement accuracy too. The requirement of data accuracy is essential in assessing the proportionality and the suitability of the measure of containment and contrast of the epidemiological emergency. I read with interest the decision by the INAI, who is hosting us, of the 3rd of June of this year regarding the request for rectification of inaccurate data in the vaccination portal after it was entered a number of elements incorrectly upon registration. The adoption of a legislative measure is an occasion to implement transparency too. The law should indicate the specific purposes pursued, as we know, the characteristics of the processing and those who can process the data collected in relation to the issues and issuance and control of certifications. This having in mind that the absence of clear indication regarding the controllership of the processing does not allow data subject to exercise their rights. This was also emphasized by the same decision by INAI I have just mentioned. Transparency, we should recall, is also a question of trust and acceptability. As the European Data Protection Supervisory Wojciech Wiewiórowski commented in presenting the opinion on the Green Certificate to the LIBE Committee of the European Parliament, while citizens have a right to use their data to prove their commitment to make their environment a healthy and safe one, they also have the right to know what is really certified by the certificate they get and the right to trust, not only the right to be mutually accepted. An effective strategy to combat the pandemic involves citizens' trust, as it was also acknowledged by the Council of Europe Parliamentary Assembly in its Resolution 2383 of this year, which spoke about the role of a clear legal basis for ensuring the acceptability of measures that may restrict rights or lead to potentially discriminatory treatment. In other words, as the sharing of health information with one's personal doctor should be founded on trust, the same should be with any kind of processing carried out by authorities in the interest of public health. The higher the risk of surveillance on individuals is, the higher should be the possibility for citizens to control public health policies. Finally, the law is an occasion also to set forth specific data retention periods as well as specific security and privacy by design measures. Having in mind that, as in the management of other public interest situations where data processing plays a role, the contrast to the pandemic has triggered public and private partnership. Although this is not a novelty of the current health crisis, it deserves the highest attention in order to prevent the exposure of critical information related to individuals to purposes not legitimately expected by the data subjects. The different apps used by the governments in conjunction with vaccination certificates have revealed a big variety of features, some of which compliant with data protection parameters, some others much more obscure in the purposes and the consequences for the personal data processed. Needless to say, in the assessment of the elements I've just recalled, supervisory authorities have a crucial role to play. The consultation of supervisory authorities is an indispensable step of the construction of well-balanced measures. The urgency of the measures to be adopted cannot become a reason to avoid involvement of the supervisory authorities, which are keen to provide their prompt contribution to the setting up of measures which adequately consider the data protection principles to be complied with. The prompt and substantial intervention of supervisory authorities during the preparation of a legislative act is not only a necessary procedural step to render the legislative act legitimate, but it is necessary for the authority to present methods and safeguards for the introduction of a measure necessary to contain the epidemiological emergency, while respecting data protection rules from the design stage. It is in the interest of governments too, whose political choices would be supported by the expertise of supervisory authorities on such delicate and technical issues. In this respect, let me emphasize that the Council of Europe Convention 108 Plus explicitly provides that supervisory authorities shall be consulted on proposals for any legislative or administrative measures which provide for the processing of personal data. This is a fundamental tool whose important role has become clearer and clearer precisely within the management of this unprecedented health crisis, and which should be ensured in the different legal systems as provided for by the modernized Convention 108. This is why, and please allow me to open a parenthesis in this respect, in order to make this tool and the other data protection standards ensured by Convention 108 Plus become effective, it is extremely important to reach as soon as possible an adequate number of ratification of Convention 108 Plus to allow its entering into force. This is why I allow myself to recall that it will be essential that all parties involved do their best to facilitate the prompt ratification of the protocol amending the Convention by their respective governments. Global challenges like the health crisis we have been experiencing need global standards, and for sure Convention 108 is a crucial tool to ensure high data protection standards, also through the enhancement of the role of supervisory authorities, as I said. The need for global standards is crystal clear in a crisis which has affected countries all over the world. Global cooperation in the management of this health crisis is not only altruism, it is essential for ensuring the national interest of the different states. It has become clear, although sometimes forgotten, that as long as the virus continues to spread anywhere, no country can feel truly safe. Cooperation becomes a sort of antivirus for the world, as Professor Yuval Harari noticed. The same goes for privacy global standards, without which new rooms for vulnerabilities and threats to democracy would open up. It is precisely the protection global standards embodied in the modernized convention that has served as the background for a number of activities carried out by the consultative committee I have the honor to chair. In order to assist the parties to Convention 108 in addressing privacy and data protection issues when setting up and implementing measures in view of the fight against the COVID-19 pandemic, two joint declarations by the Data Protection Commissioner of the Council of Europe and I have been published last year, which recall that general principles and rules of data protection are fully compatible and reconcilable with other fundamental rights and relevant public interests, such as public health. In the first joint statement on the right to data protection in the context of the COVID-19 pandemic, published on 3rd of March 2020, it was highlighted that states must only take temporary measures, and I will get back to this point, that are necessary and proportionate to the legitimate aim pursued, and which respect democracy, the rule of law, and human rights. In the second joint statement on digital contact tracing, published on the 28th of April 2020, it was recalled that large-scale personal data processing can only be performed when, on the basis of scientific evidence, the potential public health benefits of such digital epidemic surveillance override the benefits of other alternative solutions which would be less intrusive. On that occasion, it was also emphasized that there is a high need that these measures constitute an integral part of a national epidemiological strategy, that conditions of acceptability based on trust are ensured, that robust data security requirements are adopted, ensuring a strong link between the choice of the digital architecture used and the protection of privacy, that interoperability, transparency, temporary nature of databases, oversight and audits are ensured. These principles, which at the time were mainly thought for digital contact tracing, are of course replicable in respect of the COVID certificates and attestations, which are often accompanied by their digital versions, including the need that certificates remain available both in digital and paper-based formats to ensure the inclusion of all individuals, as also recalled by a statement published by the Council of Europe Committee of Bioethics on the 4th of May of this year. In respect of the tools and the need for privacy by design that were also explicitly considered as one of the questions raised in the introduction to my speech in today's agenda, you may be interested in knowing that the Data Protection Unit of the Council of Europe published a report entitled Digital Solutions to Fight COVID-19, which deals with the issue of how personal data are processed in the 55 state parties to Convention 108 in relation to the crisis caused by COVID-19. The report shows cases of commendable practices that have been followed by parties, such as the use of privacy impact assessment and privacy by design principles in the shaping and implementation of digital solutions to support public health measures, and those that needed to be improved, in particular in respect of the mandatory use of contact tracing app for the whole population or measures taken in a state of emergency without time limit. The Committee of Convention 108 issued also a statement precisely on COVID-19 vaccination, attestations, and data protection. On that occasion, the usefulness of means such as vaccination passes was acknowledged, as well as the legitimacy of people's wish to gain back to some of the freedoms that were restricted due to the COVID-19 pandemic. Nevertheless, it was recalled that health-related data are sensitive data, of course, which according to Article 6 of the Modernized Convention requires additional guarantees when processed, and no discrimination can be justified based on the fact that a person has not been vaccinated, whatever the reason. It was on that occasion that the committee as well suggested that alternative to the use of such tools need to be made available. And this leads me to another observation. There are two considerations that have been identified from the very beginning of the debate on the correct balancing between the need to contrast the pandemic and the preservation of human rights, and that still remain central to the discourse. The first one is exactly what I've just referred to, that alternatives to the vaccination must be ensured in order not to transform the request for a COVID pass into an indirect obligation of vaccination. As recorded by Parliament Assembly of the Council of Europe, any undue indirect pressure on people who are unable or unwilling to be vaccinated may be mitigated if COVID passes are available on grounds other than vaccination. The importance of alternatives, which was identified as a priority by the data protection community, has proven to be crucial and still very relevant, especially considering that certificates can be used not only to facilitate a safer free movement among different states, but also for additional purposes. One should recall that a number of vulnerable individuals may be affected by an improper use of certificates and the data there contained. As the Inter-American Commission on Human Rights reminds us, states must provide guarantees to protect, for example, the personal information of migrants, refugees, and other persons in context of human mobility collected through procedures related to the vaccination in view of the risk the information could be used for migration control purposes. And I now go to the second element. When assessing the proportionality of the measures taken, it has been clear from the very beginning that in order to contrast the pandemic while keeping a high level of protection of fundamental rights, the measures adopted must be of temporary nature and a part of a comprehensive, coherent, and efficient health strategy. The need to reassess the necessity of extraordinary measures was indeed considered since the first measures against the pandemic were taken, starting from the restrictions on liberties such as confinement, moving to the use of contact tracing apps to monitor and limit contagions. The provisional feature of measures is reaffirmed today when the evolution of the pandemic and the reply by science to it has brought to the need to attest vaccinations or recovery from the disease or negative tests. This is a challenge on which our attention must remain high, as there is always the temptation to perpetuate and extend measures thought and legitimized for extraordinary circumstances only, and because there is always a new emergency lurking the horizon. It is extremely important, as highlighted by the Council of Europe Parliamentary Assembly, to ensure that any system of COVID passes is strictly limited in application and duration to the needs related to the COVID-19 public health emergency, and that the infrastructure involved is not repurposed for other aims without prior democratic scrutiny and effective legal oversight. The European Court of Human Rights, that, like other regional courts, may be called upon to assess the necessity and proportionality of the measures taken to combat the pandemic, has developed a considerable case law on the interpretation of Article 15 of the European Convention on Human Rights, which contains a derogation clause and affords to contracting states, in exceptional circumstances, the possibility of derogating in a limited and supervised manner from their obligation to secure certain rights and freedoms under the Convention. While interpreting such norm, the Court has so far granted states a considerable margin of appreciation and has maintained that it falls in the first place to each contracting state, with its responsibility for the life of its nation, to determine whether that life is threatened by a public emergency, and if so, how far it is necessary to go in attempting to overcome the emergency. However, in the light of the specific requirements of Article 15, an indefinite perpetuation of the general exceptional powers of the executive is impermissible. In the toolkit for member states adopted by the Council of Europe on the 7th of April 2020, called Respecting Democracy, Rule of Law and Human Rights in the Framework of the COVID-19 Sanitary Crisis, it has been recalled that during the state of emergency, not only should the power of the government to legislate be limited by the duration of the state of emergency, but any legislation enacted during the state of emergency should also include clear time limits on the duration of these exceptional measures, like a sunset clause. According to the principle of necessity, emergency measures should achieve their purpose with minimal alteration of normal rules and procedures of democracy. As said in the toolkit I have mentioned, the power of the government to issue emergency decrees should not result in a carte blanche given by the legislator to the executive. The Venice Commission, which has published an observatory on emergency regimes, has analyzed limits to the exceptional measures to slow the spread or flatten the curve of this virus, and has consistently emphasized that state security and public safety can only be effectively guaranteed in a democracy that fully respects the rule of law. I think that I have almost exhausted the time of my intervention, and I'm going to the conclusion. Giovanni Buttarelli, whose vision has been an incredible example for all of us and who believed in the potential of the global privacy assembly, used to say that personal data tells a story about the individual, which, in the best case scenario, would be used for the common good, but in the worst may act as a boomerang against them. If we apply his words pronounced before the beginning of this pandemic to the current scenario, we would say that the story about the person told by personal data regards her health. The common good would be the preservation of public health, but also other fundamental rights, as the boomerang, to say it with Giovanni's words, here is discrimination, surveillance, and a profound attack to democracy. It is precisely against these risks that all parties must keep their attention high and engage in the construction of an appropriate balance between the need to preserve the health of people and the protection of self-determination and equality. Only in this way The attempts to fight against the health crisis, including vaccine passports and attestations, will not appear as an unreasonable and unacceptable means of limiting fundamental rights, and can indeed become a way to restart the effective enjoyment of the rights suspended during the pandemic. I thank you very much for your patience and attention, and I wish you the best continuation of this conference. Thank you.
Thank you, Alessandra, for your thoughtful remarks. And I definitely heard your call for regulators to remain clear and prompt. And I think that we've shown that in spades through the GPA. And so I really think those two aspects stood out for me. And firstly, how the questions, as you reference, around vaccine certificates are truly global. And these are questions that have to be asked by societies around the world. And so I'm very grateful for the support that the Global Privacy Assembly has been able to give to data protection authorities throughout the pandemic, particularly through our COVID-19 working group. And my second point is that the role of transparency in encouraging trust, which you underscored in your remarks. And while some might argue for a temporary suspension of the value of transparency in a crisis, the long-term impact on trust cannot be understated. And that surely is a reason for governments to reconsider their approach as the pandemic evolves. And a final thought that your remarks brought to mind is, will the pandemic have a clear end from an international perspective? So if there is now a need for vaccine boosters, then do vaccine certificates become a temporary measure that are still in place in several years' time? So thank you again on behalf of our ENI colleagues and the GPA for your thoughtful and expert keynote. Thank you, Alessandra.
It's me thanking you very much. Thank you.